Today, I am going to speak on the proposed digital personal data protection bill, which is mostly be placed in the session that is coming. Here, I purposefully chose this topic as need for online, faceless, time-bound adjudication rules. There is some sound that is coming regularly. Can we avoid that?
Sir, it is when people enter as a co-host, you would hear that, but you can ignore that. We'll take care of admitting the members.
Right. Here, the purpose of this talk is whether this digital personal data protection provides the privacy rights protection to the principal, to the data owner. Whether this proposed law has met its requirements and objectives as set out by the highest court, Supreme Court of India, in the Puttaswamy judgment, where it said right to life includes right to protection of personal data. After reading this law, when I thought of giving this, then I know there is no scope for a victim who is a principal whose data has been stolen, he has been harmed and he is in trouble, and when he complains, he is further victimized. He has no relief in the sight. When I went through the extent of this law, I found it is very, very odd. It is neither protecting the personal data nor protecting the privacy of the individual as required under fair justice system. Today, I am going to talk on that topic, how privacy rights are important in a human person and how it should be protected and why this bill has totally failed in its mission. Let me move. As you know, privacy of an individual is a fundamental right. It means if there is a violation of a fundamental right, any citizen can approach the highest court under Article 32 and the high courts under Article 226. Means it is given accorded highest priority. But it has become a matter of concern in the information technology scenario. Now, more and more deployment of digital technology tools to collect the personal data on some pretext or the anything. Without data, nothing moves. But the people who are collecting it, they are selling it for profit, making breaches, which involves privacy breaches of the individual, and left, right, and center, they are selling their data. Secondly, the persons who are supposed to keep security of those data, they are also not able to preserve it to the required extent and expected of them. So it has created a scary situation. You are listening day in and out. The personal data are being leaked. Even a scheduled bank like SBI could not preserve its data's integrity. Then you can imagine what will happen if there is no proper law to protect this privacy data. Number one. Secondly, when this is breached, is it not the duty of the law to protect the victim? Is there any bit of legislation that has fit in here where the victim, the principal whose data has gone out and it has caused a lot of harm to him, is being provided any compensation? This is what I always thought of the very important or essential part of a law. Why require a law? When somebody doesn't follow the morality, doesn't have the ethicalities, then we bring it into legal law and we want to punish. But here, instead of punishing the perpetrators of crime, they are given a better version so that they can play their game better. At the same time, the victims are further victimized. How? Step by step, I will explain you what is the intention of the apex court and how privacy of the individual is important and how there is no credence in this bill. Is it a privacy bill worth the name? We will just try to examine that issue. As you know, I don't have to speak to our professional group on the explosion of data. Day in and out, from the morning till night we sleep, we are playing with the data. Whether it is a good situation or a bad, we cannot, without that, we cannot survive. If you go to a hotel, again, you have to make digital payment. From there, your financial data goes out. If you go to any kirani shop where you purchase, there also your data is shared. If you do any activity in your life, even social activities, telephone, everything is going to be recorded. Even when you drive across, that data is also available. Means it is data. Without data, there is no human existence at all in the present day. It has become a global common and it is open participation by all in a very economic way, and therefore it has become the most popular way of communication and provides extreme mobility. But the disadvantage is national boundaries, it has no respect at all. And it can be pseudonymous, anonymous, and criminals can exploit. And there is no relief to the victims unless a proper system is put in place. Now, when you see the rates of cyber crimes going on, cyber terrorism that are occurring, and cyber wars in this real physical field is being played with the cyber issues, cyber digital equipments, then you can imagine the catastrophical way we are moving in this world. When this is the situation, when Government of India started taking data of every Indian citizen, there was no law in place to protect the data. If the data protected were to be leaked out, who will rescue the citizen when his financial data, his personal data, his whereabouts, and all those informations are going out, and his identity, if it is leaked, how he can survive? That was the situation, scary situation, where Justice K.S. Puttaswamy petitioned the Supreme Court. Supreme Court, after looking into the entire issue, the 9-judge bench gave anonymous verdict that privacy rights have to be protected at all costs because they are a part of right to life of the individual. And Constitution of India guarantees this right to each individual. There is no doubt that right to life and right to privacy are to be together. Then, if you look into the judges, what they held, in short, fundamental rights emanate from basic notions of liberty. The right to privacy imposes the state a duty to protect the individual. It also says right to life and liberty are inalienable to human existence. The Constitution must evolve to meet the aspirations. When this was told, the Supreme Court was assured that they are making necessary law to protect them. In the meanwhile, we had Sri Krishna Commission appointed for the required task. Sri Krishna Commission did a beautiful work. They come out with 2018 version along with the report, which was really citizen-centric or privacy-centric, protecting the rights of the citizens, private rights of the citizens. Unfortunately, The government took its own time, came out with a bill in 2019. It was referred to the JPC. After the JPC report, we thought we are going to have a very strong law. Unfortunately, it was withdrawn from the parliament. Very unfortunate situation. And then again, for a newborn baby, we awaited. And now what is born is nothing to do with privacy. It has no element of protecting the victims or protecting the privacy of an individual. And when it is breached, whether he gets the fair justice has become a mirage. There is absolutely nothing. This has been influenced by the non-personal data, the Chris Gopal Krishna committee, which recommends for commercialization. So government, instead of thinking, protecting the privacy rights of the individual, has shifted its gear for commercial gains at the cost of the privacy without giving them any relief. This you will see when I take up some examples of some proposals, you will understand. Digital Personal Data Protection Act. Now it has been published and comments have been called for, and I think this Saturday is the last day. Just now I spoke to our Naviji and the concerned URL is there. Kindly you can see and send your recommendations. In this, MeitY has invited feedback. At least after getting the feedback, it may improve and try to become principle-centric law. Let me tell. Now I am going to examine whether the proposed law aims at the protection of the privacy of an individual or not, has any provision made to compensate for the harms caused by the fiduciary. This is what I am going to examine in the present situation. When I had the first reading of this bill, I wanted to be named as Fiduciary Activities Protection Act. It is not a Digital Personal Data Protection Act. It should have been Fiduciary Activities Protection Act. Here, fiduciary, where he involves as a media or a middleman or processor, or he may be directly hand in glove with the dark nets, we do not know. They have been given certain standards, and if they maintain their standards, even something breaches happens, they are not going to be punished. Due diligence theory they have given in detail in this law. It is Fiduciary Activities Protection Act only, because it provides only compliance mechanism. Whatever may be the state of affairs that is going on, his reports, compliances are there. Yes. He is certified. Yes. Then fiduciary is not at fault at all. What happens if there is a breach? What happens to the harm caused? Whether any relief to be given? That is not at all spoken of in the law. No concern on the principal being a victim due to the harms caused by the breach of the data. Complaints, yes, they want victims to complain. He has nothing to do other than crying before the authorities saying that my data has been breached. Beyond that, there is no relief at all to him. He has nothing except he can go on shouting and go on praying for it. He will get nothing in return, but it will be a settlement between the Data Protection Authority and the DPO of concerned fiduciary. So fiduciary and the government will come to a settlement, whereas the fellow victim is left out in the whole game. So where is the question of protecting the victim here? Absolutely no relief to the victims or complainant. Complainant is only for the namesake. If there is a breach, he will help for the government to get connected with the fiduciary. What goes behind with them, it is not concerned of the complainant at all. He is not at all in the picture. Here, who is going to be protected with this proposed law? It's between the government and the fiduciary. They are getting themselves protected. Here, government has cleverly shields the fiduciary's activities. It is not helping the privacy person who has lost his privacy to restore his privacy, his dignity. It is not at all bothered about it. Commercial interests are overtaking the individual's rights, fiduciary rights over the fundamental rights. See, Constitution has assured us that our right to life, right to privacy are guaranteed, but this law says just the contrary. You can look into it. So rules, how can you frame if there is no substantial part in the act? Today, I intentionally call it as rules because there is no substantial law. Rules can never emerge. I will go to the next level where you will understand this better. You can see citizens' rights have no space in the proposed law other than normal rights they have explained. When my rights are all breached, I can go directly to Supreme Court. I can go directly to High Court. But they don't want us to go. So they have a law here. But this law doesn't allow me to get justice. Then what sort of law this? If I go to Supreme Court, it may allow me damages. But this law doesn't. So what is the purpose of this to the privacy of a citizen? In what way he is going to be benefited? So no substantial provision made for extending such a framework. Proposed law is fiduciary protection oriented law, needed to address the privacy concerns as guaranteed in the Constitution of the India, should become principle centric. It should speak from the views of the principal, because this is expected to protect the personal data of the principal, but principal has no role at all here. Provide protection to the fundamental rights. That should be the aim. Violations by anyone, perpetrators of crime to be punished, not only punished, they are made to pay damages, but perpetrators of the crime will go unpunished in this law, or at the most penalty. Beyond that, nothing will happen. And that penalty is full of ambiguity. It's left between the government and the commercial organization. So their commercial interest will come into play surely because of that ambiguity that has been created in the penal measures, which is unjustifiable and unfair of lawmaking. Needed to insert an exclusive part, a chapter, reliefs to the victims and principal. Then only it can be worth the name called a Digital Personal Data Protection Act. Otherwise, it is not. I go yes, you can look in. Right to grievance redressal is given in this law. What does it say? A data principal shall have the right to readily make a grievance to the with a data fiduciary. If data fiduciary doesn't answer him, then you within 7 days you can give it to the concerned authority. Matter ends. Beyond this, you have no role, and you can keep on transacting the authority, keep on attending his PH, and what you are pampered with, nothing. Except you have lost, further lost by attending this PH and making this complaint. It doesn't help you. Why should you complain? You have to, instead of this, you can directly go to courts. That may give you relief. Otherwise, this law is toothless as far as citizens' rights are concerned. I'll go a step further. You can see here, data principle, harm conduct. Now, harm has been explained in only 4 lines, whereas the earlier law had a broader parameter. Now, that harm itself has crumbled. What was the harm in the Sri Krishna Commission or in the PDP bill that was proposed? I will give a comparison. Kindly wait. And kindly note, personal data means any data about the individual identifiable by in relation. It do not figure out the nature of the personal data. What are the personal data? They have not cared to list out because they have no concern for the citizens' rights. And you can see here, personal data breach means unauthorized. Means it is they are treating, if somebody enters my computer system and breaches, then I can take a relief in IT for section 43. Otherwise, that is also not available. So the only way left for me is approach under Article 226 and Article 32. For that, why should I require this law? It's a garbage to that extent. You can look in here how data fiduciary is pampered. Data fiduciary, data processor, data protection officer. They have a beautiful role, and their functions when you look in, it is between them. Fiduciary to adopt any urgent measures to remedy the personal data breach. If there is a breach, he should set it right, mitigate any harm caused, but it doesn't talk about any compensation to be paid. What about the compensation? What about his victimized harms that have been caused? Who is going to take care of it? Who is going to be benefited? Secondly, financial penalty. You can see here, financial penalty has no parameter where privacy of breach has occurred and what is the quantum of breach and how it should be punished based on that. It's only between the department, government, and the fiduciary. And there it is full of ambiguity. So they will have to see whether that fellow has a gain or a loss. Based on that, they will levy penalty or reduce the penalty. In what way citizen will be benefited by this? Please let me know. I told you, financial penalty nowhere provides reliefs to the victims, to the harms caused, are not at all considered in the section 25. Damages or compensation to injury for the harms faced by the principal are not at all deliberated. There, these people, like a fox, cleverly eliminates this factor. Very unfortunate. We are talking about digital, what is that new term is recently the minister was publicizing. I will recollect and let you know that word. Digital Nagarik. Digital Nagarik is thrown open in the field. No compensation to the principal victims for the personal data breach and the harms caused. Now, you can see it from the objectives itself of the earlier personal data protection bill. What was it? Let me recollect. I am not going to compare with international law, which are much more strong as far as citizens' rights are concerned, and it's known to all of you. Now, you see the objectives included then processing personal data, remedial for unauthorized harmful processing. There, kindly look at the harms. The red part is what is included now. What is left out is that whiter part. If there is a financial loss or loss of property to the victims or to the principal, it is not at all a harm. No more a harm, even if you have lost your property. If you have lost your reputation, government is not bothered. The fiduciary also need not worry. If you are humiliated, you don't have to worry because it is not a harm. Any discriminatory treatment, it is not a harm. All this happens because my privacy data has been leaked, breached. Any denial or withdrawal of a service is not at all a breach. So all that white part is not at all a breach. The red part is the breach which is incorporated. Then you can imagine the harm. I have given this also, 210, the present law. You can compare how it has been tilted towards fiduciary protection. If my property is lost due to my privacy breach, I am not at all getting any protection in this law. And how do you call it as protecting the personal data of the individual? Is it worth the name? Kindly look in. The definition proposed in the law is narrow, do not address any concern. I have written wrongly as all concerns. You can see what is left out is more than what they are trying to cover. Who is going to be benefited in this? Then you look in. Now, earlier law, it had a penalty for section 25, breach of any personal data processed by the data fiduciary, harm to any data principal has to be compensated. Especially that was provided in 63 and 64, caused harm to any data principal as a result of any contravention. And 64 was much more specific, speaking on compensation. The explanation clause 64, which was submitted then to the parliament, spoke. This clause seeks to provide the data principal's right to seek the compensation from the data fiduciary in case of suffering harm. Now it is gone. It has evaporated. Then still you want to call it as personal protection, data protection law, where your rights have evaporated. There is no such compensation as well as explanations. They are not finding any place. You can look into the another one, compensation. Very specifically, they have met with the requirement of this. When principal has suffered harm as a result of any violation of any provision under this act, thereunder by data fiduciary or a data processor shall have the right to seek compensation from the data fiduciary or the data processor. There has been a direct contact between us. Now it is no more. I will file a complaint with the fiduciary. If he doesn't respond, I will go. He knows that he will not respond at all, and I will go to DPO and DPA, and they will make their own arrangements, and the citizen again is further victimized going door to door. That is what has happened in section 43A of IT Act today. My colleagues will be able to better mention it. Now, do not find any mention of this provision at all. So surprising. So data principal may seek compensation under this section by making a complaint to the adjudicating officer. Unfortunately, such system is not at all built in here. So now, unless you make a substantial law, how do you make a rule? So I want this law should have this kind of provisions made first. So where there are one or more data principals, they have each one's harm has to be met by that fiduciary. It had become a mandatory for them to give reliefs after auditing the harms caused. Now, no such role at all. You can see further, found to have caused harm to the data principal, then be ordered to pay the entire compensation for the harm. Information Technology Act, Section 43A, what we say this is an extension of 43A, has also says, if the fiduciary is negligent in implementing and maintaining reasonable security practices, he has to be covered, he can be compensated, he can also be penalized. Causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages. This is what IT Act says. Now, by bringing this out of it, they are removing this provision at all. Provision at all being losing its credence. So instead of this law, if the ITL 43A exists, at least there is chance of getting some judgments or some favorable compensation. Now, even that is missing. Friends, I don't have to speak much to this elite class on the protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Privacy right is respected by every democratic country around the globe. There are more than 140 nations who are having privacy bills as on today. But unfortunate, the biggest democracy has failed in its mission and now cleverly trying to throw something else and deviate us, saying that privacy law is there in India also. What is this privacy law? This is also given credence in the Universal Declaration of Human Rights. But the subject law do not provide the expected guarantee and the remedy to the principles for the harms caused by privacy breaches. Digital Nagarik, kindly remember our minister's words, Digital Nagarik has no space. Dear Minister, kindly we seek justice in this. That's what is required. What is the way forward now? At least when it is going to be tabled on the parliament, we must be able to raise our voices and put forth. They must provide legal framework similar to Section 64. They should compensate the principal victim for the harms caused by the fiduciary. Otherwise, the objectives required under the bill shall not be met. So substantial law is a must to make rules over it. Once substantial law is made, then for smooth delivery of justice system, for the victim who is already victimized, he should not be made to go from door to door seeking justice. Again, as it has happened in the Information Technology Act, it should be time bound, time frame must be there. Within 15 days, there must be fiduciary should compensate. Otherwise, fiduciary can be brought directly to before the High Court or Supreme Court. Such stringent things are there because it's violation of the fundamental right. They are going to distort this fundamental right and make it a fellow whom we have to run around for our rights, restoration of rights. So it should be faceless, meaning there should not be any jurisdictional compulsion. No, it is in Karnataka. You should go to Karnataka and seek justice. It is in Maharashtra. When the whole world has come around on the common platform, why should we have this kind of division? It should be all India common adjudication authority should be there. When such legal regime is expected, what is preventing this government to provide appropriate remedies which were recommended in the report, which has been set up by the same government? Very unfortunate, they are going back on their words. Despite the assurance given by the apex court, they are not following it. Whether the government that believes in minimum government, maximum governance attempts to provide such a framework, that's the question. I want our legislatures to move by being clever, to be wise. Wisdom should prevail, should not be carried away on commercial interests. Let us work for a fair personal data protection law and rescue the victim. That is what law is expected to do. It should give relief to the victim. It should not further victimize. With this, I complete my talk and thank you for this opportunity.